Hello and welcome to another edition of Law and Democracy, a podcast of election law at The Ohio State University. I'm Steve Huefner, the Deputy Director of the Election Law Program at Ohio State, and I'm pleased today to be joined by Ned Foley, the Director of our Election Law Program, Tony Gaughan, the visiting professor here at OSU this fall and the Kern Family Professor at Drake College of Law, and Terri Enns, a senior fellow of the election law program at OSU. Every time we get together, there's plenty to talk about, but I know today we thought in particular we might talk about some natural disaster impacts on our elections. Tony, tell us a little bit more about how we might try to wrestle with that issue today.
That's right, Steve. Our topic today is right out of the latest news headlines. As we record this podcast, Hurricane Milton is approaching the Gulf Coast of Florida, and the presidential election is less than a month away. So our topic is the impact of natural disasters on elections. And our first question is, what steps can election officials take to accommodate voters in areas impacted by natural disasters?
It's a question that, at the first level means election officials just ought to be planning all the time for a host of contingencies, including something like this. And most election offices are pretty good at having contingency plans in place for various unexpected impacts. But some of these natural disasters, including the potential of Milton and then what has already happened in especially Western North Carolina, are really sort of beyond what is easily preparable, I think.
Yeah, and I wonder to what extent election officials need good laws to be in place in order to have the capacity to try to facilitate voting in an emergency situation. The election officials may, in goodwill, want to do whatever they can to mitigate the damage in the situation, but if the legal regime of their state doesn't give them the authority of the tools they need, then what happens? And I noticed, I don't know if the rest of you got a chance to see this, but there was a lawsuit filed today in Georgia because of Hurricane Helene, where several civil rights organizations are going to federal court seeking a temporary restraining order to extend voter registration deadline in Georgia to get an extra week, I think it is, because of the natural disaster and its potential impact on voter registration. So we could talk about that lawsuit in particular, or just talk about the general problem that confronts all of these states.
And Ned, when you say law, I think you often think courts and I often think state legislatures. And so I was also thinking about, it's way too late for many of those kind of law changes to happen. But, the scale of disasters at this point is something that every state needs to think about and have some good, built-in flexibilities, built-in chains of command. I mean, there are so many minute details that you can't anticipate or plan for, but you can think about who's the decider at any given stage when something goes awry.
There are states that have in place statutory provisions to deal with certain kinds of contingencies, including natural disasters. And the possibility of being ready to respond to an unforeseen calamity of various kinds has been something that I know within the election administration community, it's been talked about now for many years. And I mean, we saw New York State have to respond to 9/11, which was a primary election day in the city that day. And then there was Hurricane Sandy that really, I think, threw a bit of curveball, if you will, to New Jersey in particular, although it was not on election day, but it was getting close to election day. So it's not like people haven't had some degree of warning that figuring out who, as you said, Terry, would have what kind of
Excuse me.
responsibility and what kind of authority in the event that just something needed to be done to accommodate the voting or to accommodate voters, because the voting processes weren't really going to be able to be used in what is the normal course, is something states have known about. And again, the degree to which any given state has done something to prepare has varied widely.
And
Yeah,
one that I hadn't even thought of that I saw today was, what do you do with the first responders who are now going to be potentially absent on election day, but haven't asked for, a mail ballot or whatever within the allotted time? So it's not only the people impacted directly by the disaster, but there are sort of ripple effects out for the helpers.
yeah. To me, the overriding question is, at what point does it become regrettably too late to change the rules to provide a remedy, both as a practical matter and then, functionally as a legal matter in terms of the election has to be conducted according to the rules that exist. Obviously, COVID happened 4 years ago, early enough, it happened on some it impacted primary elections in a really disruptive way in March of 2020, with some states, canceling their primaries and changing their primaries to different dates. By the time the November general election came, states had adjusted with whatever set of rules that they were going to do. Now that caused a lot of rhetorical attacks on some of those states for changing those rules that metastasize into some of the distrust that we're currently facing. So, as I think about this Georgia lawsuit or other things that North Carolina might do, I worry about both, what immediately might happen in terms of the voting rules, but then also the larger election culture in which we exist in terms of our capacity to accept results, after the polls close and the votes are counted. The Electoral Count Reform Act that Congress passed in 2022 had a new provision that said that if states, by legislature, Terry, to your point, enact laws that allow for the extension of voting beyond election day itself, this year, Tuesday, November 5th, into the following day or even following several days, those laws are valid for purposes of the federal calendar and count as constructively an extension of election day itself. But the key point is that those state laws have to be on the books, before the election happens. And my understanding, and I think this comes out of a great memo that Michael Morley, one of our election law colleagues, who's really a specialist on these emergency rules, and he's posted a memo on the election law blog, which is, as we all know, an invaluable resource that Rick Hassan operates for our community. And I think I saw this there, but I might have seen it elsewhere, that New York is the only state that has enacted a statute specifically designed to take advantage of the permission that the new federal ECRA allows. Now, maybe other states have existing laws that could be interpreted as the kind of laws that the ECRA allows, but you have to look at that on a state-by-state basis. But I think North Carolina, there is some risk that voters, are just physically not going to be able to cast ballots on November 5th, either because the polling places won't be up and running because of just the horrific devastation. I mean, I hope this doesn't happen, or the people themselves will, have been dispossessed of their homes and and so forth. And the question is, is there capacity under existing law to protect everybody who wants to vote from disenfranchisement? And if I just say one more thing, and I'm curious as to how all of you feel, to me, my mind distinguishes the voter registration issue from the actual ability to cast a ballot. Maybe I'm hard-hearted, but voter registration deadlines have existed, all year long, and there's a capacity of voters who want to register on an ongoing basis. Now, if people aren't thinking in terms of hurricanes and so forth, people are natural procrastinators and may want to wait till the last minute. But the equities, if you will, in terms of having a court change the law and change the rules on voter registration seem different to me than the need to get somebody who's a registered voter and wants to vote a ballot so they can actually cast it.
Yeah, I agree, Ned. I feel the same way with the voter registration issue. While I certainly, from a policy standpoint, encourage generous policies regarding registration, including same-day registration, from a legal standpoint, it does seem to me that's a less compelling argument than when this is early to mid-October, the election is right around the corner, versus someone who is registered, wants to vote, but just can't access either a polling place, or someone who just lost their home and doesn't have a mailing address to receive an absentee ballot. That to me is a very troubling situation, especially when you don't have laws on the books to address this particular issue. And that too is interesting because the states that are affected here are Florida, North Carolina, and Georgia, who have been on the Atlantic coast, obviously, for many thousands of years, and certainly the whole history of the United States. But I wonder if to a certain extent, so hurricane season goes to end of November, but these are states that historically tended to be one-party states, one-party Democratic states for a long time, and then became heavily Republican states after Goldwater and Nixon. And now, at least at the presidential level, Georgia and North Carolina are very competitive states. So perhaps that is one reason these states were slow to respond to changing political circumstances that meant these are states that could determine the outcome of the presidency, and a natural disaster might affect one part of the state but not another, and that could have a partisan ramification. So it's climate change, of course, is the driving force behind all of this, but there could also be just some local political history that accounts in part for why states have been slow to change when it was so apparent they needed to update their laws.
One thing, Tony, I would add to what you said is, while certainly Florida, especially in Georgia, are states that are familiar with hurricanes. Again, I'm no climate expert. I believe in climate change, but it seems to me what's happened in Western North Carolina with the way in which that hurricane impacted an area that's not on the coast was not really foreseeable, and I don't know how that affects any legal analysis, but I think folks in Western North Carolina were really caught by terrible surprise here in a way that Florida residents aren't really. I mean, there could be worse, more severe hurricanes like Milton seems like it's going to be, but that's an expectation that Florida is familiar with.
I do think that it's important to distinguish different levels of elections as we think about how we respond. And, Ned, it's been a few minutes now since you observed that at some point it may just become too late, unfortunately. But that's a question too that I think might depend on the level of election that we're talking about. With respect to the presidential election, as you know, the Electoral Count Reform Act has some provisions that come into play here. The old version of the Electoral Count Act had language in it, I think, as I recall, that talked about if a state had failed to make a choice. And there was a lot of discussion about that failed to make a choice language potentially encompassing exactly things like a natural disaster that had prevented a state from being able to participate in the process of selecting its presidential electors. And that's, of course, a nationwide event in a way that's not like any other election that we conduct. And the Electoral Count Reform Act now is, I think, what really is going to govern, at least in many respects, what can and can't be done and at what point to respond. Now, with respect to other elections, besides the presidential election, there are federal elections for Congress and there are state elections, and the way in which a state may be able to respond to a natural disaster for its own state elections are quite different. And I mentioned the primary election underway in New York on September 11th, 2001. And there the state called it off and they rescheduled the election for, I can't remember, several weeks later. And I think that was a decision that both seemed within the purview of the state authorities to make that decision and a sensible decision to have been made in that circumstance.
But as you said, Steve, I mean, whereas Hurricane Sandy was just a few days before Election Day, I think in 2012, if memory serves,
yeah.
as awful as Helene was, it's a month out from Election Day. So, and 9/11, the terrorist attack was on Election Day. So I think that's the balance of equities, if you will, or how to think about the acuteness of an emergency, depends upon the timing of the event in relationship to, Election Day itself. I mean, Terry's point about are there first responders who, didn't request an absentee ballot, and under the laws of their state now can no longer request an absentee ballot. That again, I think that'll vary state to state. And so what's our expectation there? I mean, should first responders who know that they're on call in the event that emergencies occur sort of routinely request absentee ballots in the event that they may need to use them, when they don't know? I mean, I'm kind of thinking out loud here. I mean, at some point, you can't relax every law just because something like this happens, right? I mean, Katrina happened in 2006. First responders had to respond to Katrina. First responders know that there can be events of this nature. They may not know where they occur or exactly when they occur.
I'd be much more sympathetic to that, Ned, if it wasn't that if you ask for the absentee ballot and then it turns, it's the timing of when you can vote in person after you've requested an absentee and who lets you do that and who doesn't and which one takes priority and all that. Like, so if I'm a first responder and I'm prepared and I ask for my absentee ballot and I send it back, I guess I've done what I can do and that's all great. But, there's that timing issue of, but what if I instead now would prefer to vote in person, but you can only vote provisionally because that absentee ballot was sent to you. So.
Well, that doesn't seem so harsh, I mean, you only get one vote.
Right.
Absentee voting is a reasonable way to vote. I think, if a first responder votes absentee, they should be satisfied that that's a voting method. I mean, I recognize that there is legitimate concerns about the postal system. But if a first responder or anybody else wants to void an absentee ballot they've cast by voting a provisional ballot on Election Day, that's doable, at least in most states. And then the absentee ballot will be voided and the provisional ballot will be counted once they've made sure they're not double counting the vote. So why is that a bad solution?
Is it not the other way around in some states?
It varies. It varies state to state. Yeah.
Some of them, it would avoid the provisional once the absentee shows up. So it's just, I mean, it's just, it's a small and unusual thing that we're talking about in terms of who all gets impacted. So,
well, I don't think it's so small. I mean, the thing that I'm most worried about is what happens again in the public rhetoric. In other words, is a losing candidate, and we could talk about the presidential election specifically, and then maybe congressional elections too, because control of both houses of Congress are really up for grabs this year. But let's suppose hypothetically that that it turns out that the electoral college math is such that whoever wins North Carolina wins 270 electoral votes.
Yeah.
We've been now through 2 cycles of presidential elections where, to varying degrees, obviously extremely different in 2020 with Trump, but, Hillary Clinton and many Democrats didn't think that Trump's election was a legitimate election because of their claim that Russian interference, affected that election. I think that's an inaccurate claim, and Trump, I believe, was legitimately elected in 2016. But we're in a culture where the losing side wants to discount the validity of the office holder having won, and I just worry that how is that going to play out? And it could play out in either way. I mean, a candidate could say, well, I would have won, but for the fact that all my supporters couldn't vote because of the hurricane and nobody gave them the opportunity to vote, and therefore I didn't lose I didn't lose fair and square. Is that a valid argument to think that way? If these voters who wanted to vote couldn't vote, and that might have been decisive. And the other way to claim it is, the laws, some court intervened or somebody intervened, changed the rules, and this was a fabricated result because at the last minute rules were changed. To me, it seems the paramount objective here is to be able to hold an election that people can trust the outcome of. And I think this emergency puts an acute strain on a system that's already strained in this respect. So how do we navigate these choppy waters on that point of trust? I genuinely am interested in, collectively trying to think this through.
And on that point, Ned, the geographic distribution of the electorate in terms of its partisan identification also really raises that risk. In a state like Georgia, where the Democratic electorate's overwhelmingly concentrated in metropolitan Atlanta, north central Georgia, and South Georgia is overwhelmingly Republican, it's easy to imagine a scenario where a hurricane would primarily affect South Georgia on the eve of election, preventing voters from casting their ballots. And that would undoubtedly raise a tremendous national controversy if the state didn't take steps to make sure that South Georgia voters' voices could be heard. And North Carolina is interesting too, because the infrastructure destruction is so great that polling places that would have been used for polling places have been destroyed. There are questions about the voting machines too, if they've been flooded and damaged one way or another. And although I think the Asheville area tends to be blue, as soon as you get outside of it, you're in a very, very Republican area. So these aren't the state's affected, but it's not politically neutral in terms of what parts of the state are affected. So I think that just underscores the point you made, that this is a kind of issue we have to get ahead of in a polarized country.
It seems like we're already at a place where claims of inability to participate are likely to proliferate, whether or not they are accurate. And so I think the election officials and public officials generally have 2 challenges. One is to figure out how to allow all voters to continue to participate, and the other is to figure out how to communicate that in fact has happened, when there will be claims that it hasn't.
It makes you think about how on the margins, even really sort of seemingly small things have an impact. I mean, I'm thinking about ballot drop boxes. Like if a whole area is devastated, then drop boxes become much more important as I can drive by and drop my ballot, or people taking ballots on behalf of other people. If everyone's evacuated to a safe zone in some school and it's not in their precinct, but you have to individually go drop your ballot, it just makes a difference on the margins, these rules that have been put in place without a disaster in mind, obviously, and then they impact in ways that are totally unanticipated.
Well, so let me ask this so hypothetically, let's imagine that after Election Day, the margin of victory in the presidential race is in North Carolina ends up being extraordinarily tight. Let's just say 1,000 votes. And let's imagine, during the canvassing process, the lawyers for the candidate that's behind by 1,000 votes, because both these candidates have unbelievable large and competent teams of lawyers, manages to collect over 1,000 affidavits from registered North Carolina voters, saying that they were unable to actually cast a ballot that they wanted to cast because of the hurricane, and because they were unable to the legal regime as they understood it didn't give them an ability to cast a ballot. And so you have a lawsuit in, let's say, in federal court, it could be state court, saying that the certified result should be overturned, and with the other candidate declared the winner based on these 1,000, 1,100 affidavits, that is greater than the margin of victory. How should a court respond to that lawsuit, and how should the public respond to that lawsuit and that claim?
It's a really awful scenario. I don't myself see how a court can act on that information without, figuring out whether there are at least as many affidavits that could have been collected by the candidate who was leading, right? You can't just issue a preliminary injunction or something on the basis of the affidavit submitted by the plaintiff who brings the suit. That doesn't tell you anything ultimately about the impact of the hurricane on the outcome, and whether the outcome that was reported is actually still the best outcome. So figuring out how to find out how many total voters could have submitted affidavits to that effect and what they would say is a really hard thing to do. Now, in a number of circumstances, this would be the kind of event that I would say we should just do the election over. And we do that with some frequency. It's not that often, but it occurs, but it's almost always in small local races. We redid the North Carolina 2018 congressional race for different reasons, but we don't see do-overs very often with federal offices, although there are occasions where things other than president, senators and Congress.
And the one thing that's crystal clear based on the new Electoral Count Reform Act, there's no do-over in North Carolina.
Yeah.
The question is could and should a court void the result and say, look, we can't declare the plaintiff the winner based on their 1,100 affidavits, and who knows how many affidavits on the other side could be, but the strength of these affidavits throws in doubt the certified result to the point that there really is no valid result in the state of North Carolina, and therefore North Carolina's election should be voided, and North Carolina is just not a participant in this year's electoral college, and it gets under the ECRA, its electoral votes get reduced from both the numerator and the denominator, with whatever consequence that is in terms of calculating who has a majority of electoral votes. I mean, is that a legally appropriate response, or is that totally inappropriate because it's disenfranchising the entire state of North Carolina from the presidential election?
Yeah,
Because
so
yeah.
seems legally appropriate if circumstances warrant, but how to determine whether those are in fact the circumstances is a different question. And with respect to the Electoral Count Reform Act itself, I don't know the answer to the question I'm about to pose, so I'm just curious whether people know.
I mean, is it legally appropriate? I mean, I guess I want to push back a little bit on that. I mean, North Carolina was given the opportunity as a state, as a juridical entity. North Carolina was given the opportunity by Congress under the ECRA to pass a law that would have allowed for the extension of election day. For whatever reasons, North Carolina, again, as a sovereign state, as a community of citizens in the exercise of its own self-government, decided not to pursue that statute. And the consequence of the collective decision that the state of North Carolina made with respect to its own election laws and infrastructures meant that it created a system that was more vulnerable and more susceptible to the risk of disenfranchisement because of an unforeseen, genuinely unforeseen emergency than otherwise is desirable from a policy reason. But it may be that the state of North Carolina kind of made a decision about how to conduct its election, and then it's conducted its election on that basis. And so the votes are the votes, given the rules that North Carolina created. And it might have been better if North Carolina had a different set of election laws that could have been different in a whole sorts of ways. But these are the laws that North Carolina adopted, and so it gets to participate in the electoral college system with its set of laws, and they are what they are.
And as you said, Ned, both sides have first-class lawyers, and the position they're going to take, they're not going to commit to a position before the election. They're going to need to find out who wins, and then they'll decide whether or not North Carolina has forfeited its right to do a rerun election. The other thing is about this is it seems to me it depends on what court it is as well. The North Carolina Supreme Court versus a federal court, at a certain level, the North Carolina Supreme Court, I think, would have more authority to speak to what North Carolina, whether North Carolina should have a rerun election than a federal court. And what if we ended up with a conflict?
I don't think a rerun is, I mean, I think the ECRA says election day, the electors have to be appointed on November 5th. The state gets to choose its method of appointing electors, and it can choose a popular vote as its method if it wants to, as thankfully all states do. But if November 5th comes in, this goes to Steve's point about the difference between the old ECA and the new ECRA. If November 5th comes and goes, and there has been no appointment of electors for the state of North Carolina because the popular vote failed, and North Carolina didn't enact the kind of law that the new ECRA permits, there's no chance, the legislature's not allowed to appoint electors directly, as was asserted last time around and was asserted in Florida during Bush versus Gore. Again, for other races, especially state races, governors, yeah, you could have a do-over if the state law allows it, but you got one shot to appoint your presidential electors.
But from the vantage, but there will be a result. So the candidate that prevailed under a failed election would have every reason to argue that it wasn't a failed election, and we should receive these electors. Whereas the losing candidate's going to have if they can't do a rerun, they're going to be arguing that none of these electors should count.
It's likely there's a result, but I don't know that it's a foregone conclusion that there is a result, right? I mean, in 2018 in North Carolina, there was no result in that congressional race.
I mean, in Bush versus Gore in 2000, there was talk about whether or not the Gore team should try to sort of nullify the results simply on the grounds that Florida screwed up so badly with its butterfly ballots and its hanging chads and everything else that there was nothing. I mean, there was a count, but the count had no connection to reality in terms of the will of the Florida voters. The problem for that argument in the context of presidential elections is, and this was true under the old ECA, is that if they had gotten a judicial nullification of the popular vote as it existed, that would have just given the Florida legislature the authority under the old ECA to have a substitute appointment of electors, which would have been for Bush instead of Gore. So it was a legal remedy that arguably might have existed under the old statute, but as a practical matter, it wasn't the remedy that Gore would have wanted. But that remedy's been taken. That's what's no longer feasible under the new ECRA. There's no backup mechanism of appointment by state legislatures. So there's kind of a clash. The electoral college system is so antiquated and so sort of inconsistent with the concept of one person, one vote, and the constitutional right of everybody to have. I mean, it's hard in my mind to square the two. On the one hand, we don't want to see any North Carolina voter disenfranchised for any reason, but North Carolina as a state needs to be able to participate in the electoral college system, and the fact that some subset of North Carolina voters weren't protected by the North Carolina legislature in advance through a better law. I don't know if that should disqualify the whole rest of North Carolina from participating in the electoral college system.
I mean, I see that as raising very difficult factual questions about just, I mean, to take the extreme hypothetical, it seems a little strange to say that if one precinct in North Carolina is able to conduct an election on November 5th and no other precinct is, well, we'll just take the results from that one precinct and call it North Carolina. It seems like in that circumstance, it may well be that North Carolina doesn't get to participate in the Electoral College results, given the Electoral Count Reform Act. But the question I was not sure of the answer of is whether at the time this revision was being created in the Electoral Count Reform Act, were people actively talking about the possibility of a natural disaster? And
oh yes,
that
absolutely.
was part of what the invitation to states to figure out what to do was about, natural disasters then?
I mean, I'm pretty sure in the text of the statute, the term force majeure is in
there.
Yeah, I mean, the concept is I mean, it was exactly the idea of a natural disaster or a terrorist attack like 9/11. I mean, it was supposed to be a the kind of last minute or, right on the eve of election, horrific event that disrupted the possibility of voters actually casting ballots, and that states were allowed to protect themselves against that by extending the time of voting to make sure that all voters affected by the force majeure event, could cast a ballot. So
the Electoral Count Reform Act itself is another invitation of the several that we began our discussion today talking about, to states to think about how to prepare for events like this.
Right. No, it's a loud and clear invitation to states, and I know there's been a concerted effort to try to get states to align their election laws with the new ECRA. And this is not the only need for new alignment, that, you know, there's an adjustment of the dates and the calendar in other respects. You know, there's no safe harbor deadline anymore. And instead there are, you know, absolute deadlines under the ECRA that if a state doesn't comply with, they're out of luck also. Now, there's really two different dates, and litigation can extend from the first deadline to the second deadline. December 17th is the hard and fast deadline. If a state hasn't certified, you know, its appointment of electors and had its electors actually vote on December 17th, I think under the, I mean, the ECRA is clear that that state hasn't participated in the electoral college system. And so there's been an effort to try to, you know, get state legislatures to realize that they have this mandatory obligation to make sure their recount rules and certification rules and all their litigation rules allow for completion of every process, you know, by that date certain. And very few states, some, but very few states have taken advantage of that. Again, I hope that none of that, you know, ends up being consequential. But I do worry that North Carolina's decision not to enact the kind of emergency law that the ECRA authorized, you know, may affect. I mean, I hope it's not plausibly outcome determinative, but I think that and Steve, your example of, yes, I mean, I don't think anybody would think that one precinct could stand in for all of North Carolina, but
somewhere there's a factual line.
right.
Right. And who determines that?
I don't know, either Congress or the courts, right? I mean, I guess I guess if somebody sued to try to get a judicial nullification of North Carolina's popular vote, then the court would have to say whether the facts warranted that kind of judicial nullification, right?
Right. But what a tough decision for a court.
Right.
If 95% of the electorate voted or 99%, wow, that
Well, but we're not getting, I mean, 95% of people, I mean, turnout in any of these states is not going to be
right. It'll be 60% or 63, but in terms of among voters who wanted to vote, which again is a subjective number, but as compared to in 2020, there's one part of one county that voting was extremely difficult, and it just happens to be a very red county or a blue county. That it's just that I think both sides are going to be so keenly aware of which party benefited from the difficulty voters had in this particular area, the difficulty they had in voting, that there's no way that a court would be able to hand that ruling down without people making a very pointed partisan allegation that this was motivated, and that whatever the judge's personal background is in terms of their partisan affiliation, in terms of the partisan identity the president appointed them, or their ideological leanings, it is going to be under so much scrutiny. It just seems to me this is exactly the kind of thing courts don't want to be involved in. But wow, it would be hard to escape.
Right. No, that's good. I mean, in other words, if the governor of the state and the election officials, I mean, in North Carolina, they have a board of elections, right? I mean, it's not quite the normal Secretary of State is the chief election officer situation, I think. You know, I think if they don't suspend the election as undoable ahead of time, we probably have to accept the election as, I mean, we talked in a previous podcast about no election is completely perfect, right?
Right.
These are all human endeavors. And so if the election goes forward, we have to accept the result as the best result possible under the circumstances.
And so between now and election day, we just want to hope the election officials themselves can piece together as many regular precincts as possible and as many alternative precincts as are necessary when they can't have regular precincts, and figure out what kind of balloting systems to use where they may not be able to use what they plan to use. I know on a smaller scale, we see election officials make those kinds of adjustments on the fly with authority to do so, where they will issue paper ballots to voters when their voting equipment is not working, or when it's been damaged by a flood in the basement of the school cafeteria or whatever. This is a larger scale. That's the kind of thing that may be available as a possible response here. The question really is, do the local officials have the ability to do that between now and election day?
And sometimes the technology, I mean, I'm sitting in Nevada right now where you can vote. You don't have to go to a particular precinct. They can print the ballot that you need, you know, and if that's technologically possible in one state, it sure seems like, you know, if I evacuated from Asheville because my house is flooded and I'm sitting 2 counties over or 2 precincts over and I want to vote, they should be able to give me a ballot. You know, technologically, I think we could look around a little bit more at our laboratories of democracy and make some choices that might be helpful.
There's an old expression that generals always fight the last war. And I think it's sort of true at legislatures that COVID, the COVID election in 2020 is something that I think was really informing what legislatures were thinking about in the years afterwards in terms of whether they wanted to reduce the amount of time for mail-in ballots or expand it. And here we are when it's not a pandemic, it's natural disasters that are the new battle that election officials have to fight. And they're being caught flat-footed, or might be caught flat-footed. Although again, it does seem like we're far enough out for November 5 that this is a problem that is surmountable for the reasons you said, Terri, that this is doable. We should be able to get the voters in Western North Carolina should be able to participate in this election, whatever happens in Florida. There's enough time that we should be able, the election authorities in Florida should be able to conduct a free and fair election in which the voices of the voters in Florida are heard accurately and fully.
Well, that feels like a hopeful note maybe to end today on, and also to continue to hope that Milton is not as severe as forecasts, and that people prepare for the worst, but maybe don't experience it. So, Tony, though, how about a trivia question?
Yes, Steve, yes. As our viewers may remember, our trivia question from last week was, what was the monetary limit on individual contributions to candidate campaigns during the 1972 presidential election, the year of the Watergate break-in? And the answer is, there was no limit in 1972. In fact, one of Richard Nixon's donors gave over $2 million directly to the Nixon campaign, and that was perfectly legal. That was not a part of the Watergate scandal. Of course, in 1974, the Federal Election Campaign Act was amended to establish the $1,000 contribution limit for individual donors to candidate campaigns. The contribution limit remains on the books today, although it has been indexed to inflation and is currently just over $3,000 per election. Well, our trivia question for next week continues the campaign finance theme, only it goes a little bit further back in history. The question is, what campaign finance mistake did George Washington make in his first campaign for elected office that cost him the election? The race was the 1755 Virginia House of Burgesses election. Washington was a young candidate, and he made a last-minute campaign finance mistake, a rookie mistake, if you will, and he lost the race. He never made the same mistake again, and he never lost another race during his long career in colonial, state, and national politics. So the question is, what was that mistake? Stay tuned for our next episode to find out the answer.
That's great.
That's great. Thanks, Tony. Well, that will do it for this edition of Law and Democracy. Terri and Ned and Tony, it was great to be with you. And until next time, we will send our hopes and best wishes out to everyone affected by this year's hurricanes. See you next time.